So students, your topic for today is preventive detention. So, preventive detention means detaining a person so that that person is prevented from committing any possible crime, or in other words, you can say it is an action taken by the administration on the grounds of the suspicion that some wrong actions may be done by that person concerned, and therefore that person is detained. So, preventive detention is the most contentious part of the scheme fundamental rights in the Indian Constitution. Article 22, Clause 3 provides that if the person who has been arrested or if the person who has been detained, then under preventive detention laws, the protection against arrest and detention provided in Article 22(1) and 22(2) shall not be available to that person. So, this protection that is provided under Article 22 (1) and 2 subsection, that will not be given if that person is arrested or detained under Article 22 section, section uh, 3, clause 3. So, the objective of preventive detention. The main objective of preventive detention is not to punish but to prevent the detainee from doing something which could be prejudicial to the state. The satisfaction of the concerned authority is the subjective satisfaction, and it comes with the following grounds like security of the state, public order, foreign affairs, services essential to the community. The case for on this is Maripan versus the district collector and others. In this, it was held that the object of detention and the detention laws is not to punish but to prevent the commission of a certain offense. Now, grounds for preventive detention are the security of the state, maintenance of public order, maintenance of supplies and essential services and defense, foreign affairs or security of India. A person may be detained without trial only on any or some of the above grounds, and a detainee under preventive detention can have no right of personal liberties that are guaranteed by Article 19 or Article 21. Now, safeguards that are provided in the Constitution to prevent reckless use of preventive detention. Certain safeguards are provided in the Constitution. First is that a person may be taken to preventive custody only for 3 months at first instance, and if the period of detention is extended beyond these 3 months, then the case will be referred to the advisory board, which will consist of persons with the qualifications appointed as judge of high court, and the period of detention may be extended beyond 3 months only by the approval of this advisory board. Secondly, the detainee is entitled to know the grounds of his detention, and the state, however, may refuse to divulge the grounds of detention if it is in the public interest to do so. This power conferred on the state leaves the scope for arbitrary action on the part of the authorities. Thirdly, detaining authorities must give the detainee earliest opportunities for making representation against the detention. So, these safeguards are designed to minimize the misuse of preventive detention, and it is because of these safeguards that the preventive detention can basically be a denial of liberty and finds a place on the chapter on fundamental rights. These safeguards are not available to enemy aliens. Constitutional validity of preventive detention law. So, article in Ahmad Noor Mohammad Bhati versus State of Gujarat, a three-judge bench of Supreme Court, it was upholding the validity of the power of police under Section 151 of Criminal Procedure Code 1973 to arrest and detain of a person without a warrant to prevent the commission of a cognizable offence. ruled that a provision could not be held to be unreasonable as arbitrary and therefore unconstitutionally merely because the police officer might abuse this authority. This Preventive Detention Act is necessary tool in hands of the executive, which authorizes them to arrest any person from whom reasonable suspicion arises that he can commit any cognizable offense or his activities are prejudicial to law and order to state or to state, and the police can arrest that person without warrant. Another case was A.K. Gopalan versus the state of Madras. In this, the Preventive Detention Act 1950, with the exception of Section 14 thereof, did not contravene any of the articles of Constitution, and even though Section 14 was ultra vires, inasmuch as it contravened the provisions of Article 22 of the Constitution, as this section was severable from the remaining sections of the Act, and the invalidity of Section 14 did not affect the validity of the Act as a whole, and the detention of the petitioner was not illegal. Thank you.